Good morning, everyone. Happy Friday. I hope you are enjoying the fantastic weather we are having here in London. My name is Benjamin O'Connor, and I'm a director here at NLA. And I'm delighted to welcome you to this morning's event, which is part of our What Next Business Advice series. And today our focus is on legal advice. Over the past few months, our programme has shifted to digital, but as some restrictions begin to lift, we are working on new content to combine digital and in-person or live events from September. We are, of course, paying close attention to government advice, so please do check our website, nla.london, for more information on upcoming events and activities. And make sure you're signed up to our newsletters to receive our weekly events mailer on Tuesdays and New London Weekly on Fridays. Over the next hour, we're going to be hearing some key insights from legal experts from NLA partner and real estate specialist Forsters. Our three speakers will focus on employment law, construction, and property disputes. These events are a unique opportunity to gain valuable access to knowledge and advice from across our membership network. So please remember that you can post questions throughout using the Zoom Q&A function at the bottom of your screen, and I'll try and get to as many of your questions as possible towards the end of the event. Our first speaker today is going to be focusing on employment law. I'd like to introduce Joe Beeston, Senior Associate in the Employment Team at Forsters. Joe, over to you. Oh, I think you need to unmute yourself, Joe.
Sorry, hopefully that's better. You can hear me now. Well,
yes,
thank you very much for having me on this morning. I've been asked to talk a little bit about COVID-19 and the effects it's had on employers and employment law over the last few months. And I must say that there's been a fair amount of changes, impacts and concerns over the last few months, and perhaps slightly too many to squeeze into a 10-minute soundbite. But I'm going to try and talk about three sort of key areas that often are of interest to both employers and employees. And they're listed on the next slide. So we're going to look at the furlough scheme, we're going to look at redundancies, and then lastly, we're going to look briefly at reopening the office and what we need to think about in that respect. So perhaps moving then onto the first topic, which is the furlough scheme, or to give it its full name, the Coronavirus Job Retention Scheme. And I think this really has been a bit of a lifeline, perhaps a temporary lifeline in some cases for many businesses in the property sector. And under the original scheme, it was fairly simple. An employer could designate an employee as being a furloughed worker, meaning that person couldn't do any work, but the employer in return could claim back 80% of their salary under the furlough scheme, along with national insurance contributions and pension contributions up to a maximum of £2,500. And normally the employee would need to agree to that because it would involve their salary changing. But faced with the prospect of a potential redundancy, most people who were asked to be furloughed volunteered and were very happy to do so. And we've seen many of our property clients take advantage of the scheme when it first opened, and they're continuing to do so under its new form. And on the next slide, we list a few changes to the scheme over recent times. The scheme has been extended on 2 occasions now, and it's due to officially end at the end of October. And what we are now able to do is to do something which is known as flexi furlough. And unlike the old scheme where employees had to not do any work for their employer, what employers and employees can now agree is that the employee comes back and works for part of the week or part of the month and then remain on furlough for the remainder. So for example, let's say an architect's business furloughed a junior architect. Things are now starting to pick up. A new project is sort of starting to grow legs. You need that junior architect to come back 2 days a week. You can agree that on Monday and Tuesday, they would come to work and they would be paid their normal rate. And then they'd be furloughed for Wednesday, Thursday and Friday, during which they would receive their lower rate of pay and for which the employer can claim back under the furlough leave scheme. So it's really designed now to give everyone that flexibility as we start to reopen, as things start gradually to go back to normal and people are needed to do stuff. The furlough scheme has evolved with it. But obviously it's very expensive. And I think perhaps the scheme has been more popular than the government initially thought. And so what the government has decided is not only will the scheme stop at the end of October, but for the next 3 months, the contributions that the government will make shall be reduced. So for example, as of next month, the employer cannot claim back national insurance and pension contributions. They will need to pay for those themselves. And then in September, rather than the government contributing 80% of salaries, it will be reduced to 70% and then further reduced to 60% in October, albeit the employee still needs to receive the pay they've been receiving throughout the period to date. So essentially what it really means is the employer needs to pay 10% more in September and 20% more in October. So in essence, the scheme is becoming perhaps a little less attractive. And the concern is that now the costs to the employer have started to increase, and or at the end of the furlough leave period in October, there will be mass redundancies, which obviously people are very concerned about. And what the government has recently announced is a furlough bonus scheme, which is really aimed at avoiding these mass layoffs that people are expecting to happen at the end of October. And the way the bonus scheme works is if an employer brings somebody back from furlough leave and they keep them employed until January 2021, then they will receive £1,000 per employee. Now, in my view, I don't think this is really going to work. If an employer wants somebody back because they've got work for them to do, then they will bring them back and retain them in any event. If, on the other hand, they don't think they're going to need staff, it's unlikely they're going to bring them back, pay them for 3 months until the end of January 2021 on their account, i.e. not being able to claim it back purely to receive a £1,000 bonus next year. I don't think the economics will stack up for most employers. So whether or not this bonus scheme will work is yet to be seen, but I think the general consensus is it probably won't. So sadly, I think we are expecting there to be redundancies on the horizon. And we see in the press every day a new news story about another large organisation making substantial layoffs. And I think that's probably a neat segue into the next slide, which is redundancies. And we at Forsters are certainly seeing an increase in requests, both from employers wanting to make staff redundant and employees who have been made redundant in the property sector, wanting advice on their rights and how to go about doing things. And really what we're seeing is sort of two key reasons for redundancies at the moment. One is due to COVID, a company has decided to take drastic action, for example, closing an office, and therefore people in that office are no longer required. We actually recently helped a small property developer. They had a small outpost in London and their lease was due for renewal at the end of this year. And they've just decided the world is too risky at the moment to take on another long-term lease. They're just going to close the office. So clearly all of those London employees will need to be made redundant. And then the other perhaps more common reason we're seeing is companies simply saying, look, we need to save cost. We have to save money to remain a viable business, and therefore we're looking at each of our populations and seeing whether savings can be made. So for example, if you've got 5 senior managers in a team, they may say, well, actually, we only really want 4 going forwards, and so one of you will need to be made redundant. So that's the more common approach we're seeing. There's still roles to be done, but employers are wanting fewer people to do those in order to save cost. And if we move on to the next slide, I mean, as I say, in the market, we're certainly seeing redundancies taking place now. And often the question is asked, well, why are redundancies happening right now? We've got the furlough scheme that runs until October. Why aren't people using that and dealing with redundancies at a later point? And I think really there are a few reasons for that. Firstly, whilst obviously we've got no certainty as to what's going to happen going forwards, it's clear that COVID-19 isn't going to disappear overnight. This is with us now for some time to deal with. And so the appetite of wait and see that many employers had at the beginning of lockdown and the start of the pandemic has now waned, and they realise actually we need to make some tough decisions. And so why delay those decisions? Let's get on with it. As I've mentioned, the furlough scheme's attractiveness is reducing because costs to the employer are now starting to increase in the coming months. Again, a reason why taking action now is probably worthwhile doing. But also, and perhaps more importantly, for an employer to make somebody redundant, there's a certain process they need to follow. And that process, depending on how many people are being made redundant, could take several weeks. And so if an employer waited until the end of the furlough leave period in October and then made redundancies, it would have to follow that process in November and December, when those employees are still employed by it and they'll be receiving their normal pay, and the government and the employer won't be able to claim any monies back for that period under the scheme. Whereas if they start doing redundancies now and following the processes now, then the employees are still furloughed and the employer can claim those monies back under the scheme. So it's often economically viable, or more economically viable, to start taking action now, because all of these processes can be done and at a time when the employer can look to claim back the staff costs. And finally, when somebody is made redundant, they're entitled to a redundancy payment, and they're also entitled to their notice pay. And normally, employers would simply say, okay, you're entitled to 4 weeks notice, we're making you redundant, we're going to make you a payment equal to your notice pay and your redundancy pay, and let's draw a line in the sand. But what the furlough scheme now allows employers to do, and it's become clear over the last couple of weeks this is permissible, is an employer can make somebody redundant and ask them to work out their notice period on furlough and claim that money back under the scheme. So rather than paying someone that 4-week notice pay, they can put them on notice and make them stay on furlough for 4 weeks, and again claim those monies back under the scheme. So there are lots of sort of financial reasons why actually making redundancies now makes sense, which is why we're seeing all of the news stories at the moment. And in terms of the legal complexities of making somebody redundant, you know, it can be tricky. It's especially so where you're dealing with employees who have had or been with you for more than 2 years, because they benefit from special employment rights, which means they can't be dismissed unfairly. And so in that case, for an employer to make somebody redundant fairly, they need to do 2 things. One, have a good reason, and clearly a redundant reason would be a good reason. But they also, and that process will vary depending on the facts, but it would involve, for example, you know, consulting with staff, perhaps pooling staff with other members in a similar role, scoring them using objective criteria, listening to staff, and so on. And that's often where employers can fall foul. They don't follow that process, and that in turn leads to potential challenges. And you know, from the individual's perspective, when employees come to me, I'm doing one at the moment with an architect who's been made redundant, and the employer just did not follow that fair process. So we're able to challenge the decision for that reason. And as I say, if somebody's made redundant, they're entitled to their notice and to a redundancy payment. The redundancy payment is based on a statutory formula, depending on how long you've been employed and your age and your salary and so on. But it may well be that the company that is making the redundancies operate some enhanced package, so 1 week per year of service or 2 weeks per year of service as well. And you know, what we often see, and it may be employees are asked to engage in such process, employers, some of them like to take pretty sort of risk adverse approaches, and if they think they've made a mistake in the process, or if they're concerned an employee might bring a claim against them, they will offer them a bit more in order for that employee to waive any claims against them. So that's really all I was going to say on redundancies. Sadly, they are becoming a bit of a reality, and hopefully, you know, it won't last forever, which kind of leads on to the next slide. And this is a very sort of challenging topic, so I've only got time to sort of mention some of the brief issues to think about, which are listed on the next slide. But obviously, you know, we are starting to see a reopening of the economy, and offices are very gradually starting to reopen. And the government has changed its advice really in recent weeks. We had the rhetoric, if you can work from home, do so. That's now changed, where basically if an employer can create a safe working environment, then employers can ask staff to return. So we are starting to see that change in sands. I think practically most offices and most clients we work with still have a lot of people working from home, and probably will do for the foreseeable future. But we are starting to see a slight change. So it'd be interesting to see how that pans out in the next few weeks. And I think in terms of making sure we do things properly, communicating with staff is of paramount importance. There are some legal obligations on staff to consult with their employers in relation to health and safety aspects. But leaving that aside, staff are naturally very nervous, understandably, at the moment. And so engaging with staff through workplace surveys to understand what their concerns are and think of ways to alleviate those concerns are vitally important. It's also important for employers to carry out health and safety assessments. And in fact, there is an expectation for employers to publish on their website their COVID-19 health and safety assessment at work. Look at the environment. What do you need? Do you need PPE? Do you need screen shields? Do you need sort of one-way systems throughout the office? Do you need hand sanitizer and so on? It's really important to think of all of these things and record them in the health and safety assessment. And the government has produced some very detailed guidance now for various industries, including offices, on how employers can make their office COVID-19 secure. They're quite long, the guidance notes, but certainly give it a good steer as to what's expected. And then finally, it's likely we will have to change working practices. For example, you may want people coming in later and leaving later to miss rush hour if travelling is a key concern for staff. You may decide you can't fit the whole team back at any one time in order to comply with social distancing. So you may have team A, team B. Team A comes in one week, team B comes in the next week. All of these practical solutions are things to think about, but it's vitally important that you sort of speak to staff and get their views. And very finally, conscious of time, dealing with tricky HR issues is going to be a real issue. There will be contentions on the horizon. Some people will just not want to go back to the office for no real reason other than they just don't really fancy getting on the tube and potentially contracting COVID. How do you deal with that? How do you make sure people are dealt with fairly? There aren't any easy answers, I'm afraid, and it's all going to be fact dependent. So I'm sure we'll have a bit more clarity in recent months when these things start appearing. But it's just important for businesses to start thinking about those now, just so if those issues do arise, then they know what they're going to say. And finally, don't forget those people who are working from home. People often got sent on working from home rotas as a bit of a knee-jerk reaction. Nobody really thought too much about it. If it is going to continue, employers still have a duty of care to those staff to make sure they've got safe working environments at home. They should be doing health and safety assessments at the employee's address, not physical inspections, but certainly asking the employee to consider their working environment and making sure they're safe and asking them to confirm they've done that and so on. So just don't forget about those working from home as well. So that's what I was planning on saying on that. Conscious of time, I think I've sort of overdone my bit, so I'll pass back to Ben.
Great, thank you very much, Joe. Obviously, it's a huge topic, and with all of these events, we try and cram it into sort of 10 or 15 minutes. So Joe there, who covered furlough redundancies and the reopening of offices, for those of you who just joined, if you do have any questions about any of those topics, do pop your questions in the Q&A function at the bottom of the Zoom screen. Our next speaker is Emily Holstock, who's going to be focusing on construction. Emily, over to you.
Thanks, Ben, and thanks very much for inviting me to be here this morning. It's a pleasure. As Ben mentioned in the introduction, I'm a construction lawyer and I do contentious and non-contentious construction work. So that can be anything from drafting and negotiating building contracts and professional team appointments, right through to advice on strategic issues if issues arise on development projects, and also ultimately dispute resolution in the courts and adjudication. As I'm sure you'll imagine, it's been extremely busy actually in the construction sector for the last few months, in part created by all of the uncertainty that has arisen with kind of lack of government guidance specific to the construction sector, which thankfully we are now seeing. I could have chosen hundreds of different things to talk about today, but what I've chosen to focus on are 3 issues shown on the next slide, which all relate principally to the effects of COVID-19 on construction works on site. So I'll be looking at the effects of COVID-19 where construction contracts were placed either at the back end of last year or early this year before anybody knew about COVID-19, where the contracts probably don't deal expressly with it at all. The second issue, looking at some of the things that we're seeing commonly being requested by both developers and contractors when negotiating building contracts for works which are about to start or are being tendered. And then finally, just some thoughts on practical things that we're seeing at the moment and that we're likely to see in the next 12 to 24 months as we continue to deal with the challenges of COVID-19 and, dare I say it, the possibility of a second wave. Taking issue number 1 first then, where I'm talking about the effects of COVID-19 within the existing contracts, as I say, that is building contracts which were already in place sort of back end of last year or very early on this year, before anyone really realised what a significant impact COVID-19 was going to be when it was declared a pandemic. I'm going to talk principally about the JCT suite of contracts, which is a suite we use most frequently here in the UK. There are, of course, others, and they're all slightly different, which makes it really important when you're thinking about some of the issues that I'm going to talk about to look at the terms of your specific contract, because they are all slightly different. I think there are 4 main issues to talk about when looking at current contracts, and these are set out on the next slide. The first one then is time. So every building contract will contain a date or dates by which the works need to be completed by, and that is the contractual completion date. And often that will have liquidated damages or some other financial, not a penalty, but a financial consequence of a failure to complete on time. And every building contract will also contain a list of circumstances which entitles the contractor to make a claim for an extension to the date or dates that you've agreed. In the JCT, that is called a list of relevant events. And so the question when considering COVID-19 is there an extension of time event in the JCT that could entitle a contractor to come back to the developer and say, I'm very sorry, it's just impossible now for us to complete the works on the date that we agreed when we signed the contract? And that's unfortunately a really complicated question. Pandemics and epidemics are really not dealt with in the JCT at all. There is a relevant event, force majeure, which lots of people are talking about at the moment in many different contexts. Under the JCT, it is not defined. It is not given any particular meaning in construction case law. So I think we're likely to see a few cases coming through the courts in the next 12 to 24 months on how we interpret that provision and whether or not it applies. And there's also a relevant event which talks about the exercise by the government of a statutory power which affects the works. And again, there's been quite a lot of commentary in the construction industry about whether or not that might apply to give a contractor more time to finish a project. That again is not an easy question. And the reason for that is that it talks about a statutory power, and a lot of what has been introduced recently has been guidance, either from the government or from Public Health England, Construction Leadership Council, different bodies, and that doesn't have the force of law. But there are bits of legislation related to COVID which do have the force of law. So in each case, it's going to be really important for the person who's administering the contract to work out what exactly the cause of the delay has been and whether or not we think that falls within one of the events in the contract. The other point just to mention on time is that the contractor is always under a best endeavours obligation in a JCT to mitigate the consequences of any delay. And that is a really high threshold for a contractor to try and satisfy. So to take a practical example, if a contractor is struggling to get materials from, let's say, northern Italy, that was a big issue at the start of the pandemic when Italy was slightly ahead of us on the curve, and we weren't getting supplies in this country. A contractor is therefore required to exercise best endeavours to mitigate the consequences of that. And that could include going to an alternative supplier here and perhaps spending more money to get materials to try and keep the programme. And again, that's going to be really fact specific as to what best endeavours is on any project, but it's just something to bear in mind when you're looking at extensions of time claims under a building contract. The second point then is money. Is the contractor ever entitled to come back to an employer to ask for more money because the price of the works has gone up, or it's now paying the masks and hand sanitizer and that kind of thing, or it's paying additional prelims because the programme for the works is longer? The answer to that under a JCT that's already in place is probably a little bit more straightforward, in that there are no obvious circumstances set out in a JCT where a contractor can come back and ask for more money. There is a slight nuance on that, which I'll talk about in a second, to do with suspension, but otherwise that's a relatively straightforward question. I have seen some contractors ask for more money, and they've kind of relied on various different provisions of a building contract, but I haven't yet seen a coherent argument from a contractor that there is an entitlement there. I just want to touch then on suspension and termination, really, because like all contracts, building contracts have suspension and termination provisions in them. Suspension first then. The interesting issue here is that we saw at the outset of lockdown a number of clients who actually wanted their contractor to stop works on site for a short period of time, particularly if it was works to, for example, an office building where the whole office was ideally going to be shut, or if the employer just wanted to save money by not paying a contractor, or wanted to do the right thing by not having the contractor travelling to site on the tube during the kind of early stages of lockdown. And that is an important distinction, because under a JCT contract, if an employer instructs the works to be suspended or postponed, that does allow the contractor to claim extra time and extra money. So when we're thinking about the possibility of a second wave and possible further lockdowns and employers possibly exercising these kinds of rights again, it's really important to be mindful of what the contractual consequences of that suspension might be. Conversely, if the contractor decides just to suspend works on site, the rules are very different. So it's really important in each case just to work out what it is the employer and the contractor want to do, and if possible, come to a sort of mutual agreement as to what the contractual consequences of that will be. And then finally, just to touch on termination, the JCT has got quite complicated termination provisions in it, and it does allow either an employer or a contractor to terminate a contract if force majeure circumstances or statutory powers have been exercised for a defined period of time, which will vary from contract to contract, but typically it's about 2 months. We haven't seen anybody trying to terminate contracts on the back of those provisions yet, because it was quite unlikely that the circumstances had applied for 2 months. I think more sites shut down if they did at all for 2 or 3 weeks before contractors started to kind of put procedures in place. But again, it's just something to bear in mind that if there is a serious second wave, either nationally or more regionally, that if the site is shut down for a period of time, certain contractual rights might apply. And if you're an employer, you may not want the contractor to try and get out of the contract by exercising those rights. And conversely, if you're a contractor, you don't want an employer to terminate your contract and potentially a huge source of work for you. On to the next slide then, and the second topic, which is negotiation issues and considerations for future building contracts. We're obviously in a position now where we've been living with COVID-19 in the construction industry for several months. And we're likely to be living with it for a considerable time to come. And the benefit of this is that both employers and contractors and the professional team are able to understand something of what the likely effects of COVID are going to be on a construction project. And I've just set out on the next slide some of the things that we're seeing commonly. And the first thing to say is that in respect of contracts where works are being tendered now, have an open conversation at the outset with your contractor. What are they pricing and programming for when they come to you and they say, we think we can do the works in 18 weeks and we think it's going to cost £1 million? Have they programmed for the current guidance and the social distancing 1 metre plus or ideally 2 metres rules? have they factored that into their programme or not? And that will dramatically affect how we then go about drafting the building contract. And we are seeing, because of the uncertainties that I've just talked about in how the JCT is interpreted, particularly on extensions of time, pretty much every building contract I'm dealing with at the moment now has a bespoke COVID-19 clause in it, which sets out the risk allocation between the employer and the contractor for the term of the project. Typically, what we're seeing being included in those clauses include lack of available labour, which might be because people can't get to site because they're shut down, or because of a localised outbreak on site, meaning that everybody is unable to come to site to work because they're in quarantine. Lack of availability of materials, either from this country or from abroad. The possibility of there being either further or more onerous restrictions on working, and conversely, what happens if the government loosens current restrictions, because that should in theory speed up the works. The possibility, and actually really the likelihood, of further guidance or legislation that needs to be factored into a risk allocation. And then finally also insolvency in the supply chain. One of the unhappy side effects obviously of the strain on the construction sector and sites being shut down and cash flow difficulties is that contractors who typically work on very tight margins, and particularly smaller subcontractors, are facing financial difficulties, and we're already starting to see the effects of that in the construction industry. Obviously that's a huge issue either for a developer if their main contractor goes bust partway through developing a project, and getting someone else in to finish the works can be very complicated and very expensive. And similarly, if you're a contractor, losing a subcontractor in the supply chain is obviously very difficult as well. And finally, just to touch on bespoke suspension and termination provisions, I mentioned that these are quite complicated in a building contract. So what we're seeing is a number of clients looking to agree bespoke provisions so that both parties to the contract are really clear from the outset when works might be suspended or terminated specifically due to COVID-19. And sometimes this means disapplying provisions of the JCT which would otherwise apply, and sometimes this means completely bespoke drafting. Next slide then. What changes might we see in the construction industry due to COVID-19? And on the following slide, I've just written a few of these out. I think in the short term, unfortunately, as I've touched on, we are likely to see more and more contractor insolvencies. There are various ways in which employers and contractors can safeguard themselves against the risk of insolvency of the other party to the contract. I don't have time to touch on them here, but I'm happy to touch on them in the Q&A if that's helpful. We're talking obviously about things like parent company guarantees, bonds, vesting for off-site materials and that kind of thing. I think we're also going to see considerable uncertainty whilst the courts and adjudicators are interpreting contractual provisions, particularly around extensions of time and loss and expense. And while that uncertainty subsists, we will continue, I'm sure, to see bespoke amendments to building contracts to talk about the risk allocation for COVID-19. As a general comment, I have to say, I think employers of contractors have been really open with each other about risk allocation on COVID, and every building contract that I've done is different, and the risk allocation will always be slightly different depending on the type of project and the effects of increases in price and on programme. But it's been really interesting actually, and a happy thing for me to see all of the what would I say, to see the kind of collaborative conversations that are going on, because typically negotiating a building contract can be quite adversarial sometimes. I think we'll also see bespoke amendments to deal with pandemics and epidemics more generally. Most of the contract drafting that we're doing at the moment relates to COVID-19 or a variant thereof. But I think people are now naturally more concerned about future epidemics and pandemics, and I think we'll see drafting to that effect in a building contract. And then in the longer term, I'm sure as the JCT, the NEC and the other standard forms look to revise their editions, I'm sure that they will start specifically to address risk allocation in terms of pandemics and epidemics. I think that's very likely indeed. And that's all that I would like to say for the moment, but obviously happy to take any questions on any other aspects of construction and COVID-19 at the end. Thank you.
Great, thank you very much, Emily. And as Emily said, if you do have any questions for her on the construction piece, then do please pop a question in the Q&A box. Our next speaker today is Jonathan Ross, who's in the property litigation team at Forsters, who's going to be talking about property disputes. Jonathan, over to you.
Thank you. Good morning, everyone. I'm going to touch very quickly on 5 subjects to do with leases and the current position. I'm going to discuss whether the current leases are fit for purpose. Is the leasing model broken? I'm going to discuss 1954 Act lease renewals and are they now the tenant's domain? Then I'm going to move on to change of use and the ability of tenants to adapt their premises to different uses in this market. Then I'm going to briefly talk about insurance cover, given the fact that COVID has exposed a lack of insurance for both landlords and tenants in relation to pandemics and the effect on rent collection. And lastly, I'm going to talk very quickly about rent collection, or more accurately, rent default in the current market, which has been keeping us litigators incredibly busy. So coming back to the leasing model, I'm embarrassed to say that when I started practicing, tenants wanted long leases. 35 years was not uncommon. They would invest in the premises. They would amortize the expenditure over 35 years. So there were tax advantages in having longer leases. And of course, longer leases meant rent reviews, which was a very good source of income for surveyors. The problem before COVID was that leases were too long, but they were too expensive for many tenants. They faced rates, substantial business rates, expenditure, and other expenditures. And even before COVID, there was this problem between the likes of Amazon, who didn't have the same expenditure, and the retailers and the tenants that were paying full rents for accommodation. The reason why leases are long, why they have fixed rents payable quarterly in advance, is that they are institutionally acceptable. They're the basis for many pension funds. They provide valuation certainty. They're much easier to assign because the tenant just takes on the clear obligations to pay a fixed rent. They have full repairing obligations because often they are for a reasonable period of time. The standard institutional lease now being 10 years, perhaps with a break after 5 years. So they give certainty. But what the market is saying is we don't want that anymore. We want flexibility. We want to share the risk with landlords. Tenants are saying we want turnover rents so that we all invest, certainly in retail and in hospitality, in the project. We want flexibility. We want to be able to move if our business is not successful. And we want landlords to be entitled to terminate our occupancy if it's not producing enough income. So we've got to have all-round flexibility. And what is also being said is that leases are too cumbersome, they're too long, they take too much time to agree. We want shorter, clear, standard vanilla leases that everyone can just sign up to. And generally more towards a serviced occupier model to give that sort of flexibility. Of course, for the institutional market, this is a real problem. You'll see that many large property companies cannot do valuations at the moment because there's so much uncertainty as to what property is worth. And they fear that turnover rents and that sort of flexibility will cause even greater uncertainty. So far as turnover rents are concerned, what they are is a payment based upon gross turnover, usually, with the margin, the profit, dictating how much of the turnover the landlord will normally take. So if you've got very large turnover but low profit, then you'll ask for a smaller percentage to be payable to the landlord. The intention is to share the risk. to make it a joint venture and to allow unsuccessful operations to close down and generally be replaced. But that model changes things dramatically. If you're going to have flexibility, who's going to be responsible for repair? Is it the landlord that's going to have to take responsibility for that throughout? It's a completely different form of lease and relationship. It was interesting to see that Legal & General have come out with a plan to try and incorporate this and lead in terms of new initiatives. They have proposed 4 different leasing structures focused on turnover for many of them. They've got their flexi arrangement, which is for startups generally. It's a very short-term arrangement based purely on a turnover rent. They then have their operational, they call it, which is a bit longer, 3 to 5 years, again based on turnover, but with the ability to break if performance doesn't reach certain standards. They've then got their flagship, which is a traditional long-term lease with a fixed rent, these days probably payable monthly. And then they have their flexi flagship, which is a mixture of those. So you have a longer term lease with turnover and more flexibility in terms of breaks. So the market is changing. The fact is that tenant demand will dictate what landlords are prepared to agree to. And the effect of COVID on top of what was already a very difficult market is transformational. I mean, everything is now up for grabs, and the whole world of leasing is going to change going forward. There's no doubt about that. In terms of tenants who are facing lease renewals, they're now very much in charge. If you read about rental forecasts, they're all very pessimistic. Office is predicted, I see from today's paper, to go down 4 to 7%. Retail 10 to 14%. So tenants who want to renew will be very much in demand. Landlords want to keep them and will be agreeable to concessions, which may well include turnover rents on renewal. The courts have never really had to decide whether a tenant can renew on a turnover rent where it was a fixed rent before. But the more popular that becomes, the more acceptable to landlords, the more likely the courts are going to say that's a reasonable change. It's likely that a lot of lease renewals will be focused on very flexible terms, turnover rents, the ability to have a lease of 3 years or something short, and the ability to break unconditionally if the operation is not successful for the tenant. In terms of office use, there's a lot of talk about moving to the suburbs. It's interesting to see in today's paper again that Westfield are going to actually take some of their retail space and transfer it to office. They've got the House of Fraser store down in Shepherd's Bush, which they're going to transfer to office. And there's been some substantial office investments in Canary Wharf and elsewhere. So the office market isn't dead. It's just going through a change. Obviously, once people are reassured about travel and such like, then one expects a move back to the city centres and office occupational use. John Lewis have closed 8 of their stores. 60% of their trade is now online. They are saying that some of their surplus space they're going to change to residential. That's fine if you own it freehold. If you own it leasehold, then obtaining change of use is something that will need landlord's consent. There are a lot of very long leases which property companies own, certainly on estates and such like, where if the landlord restricts use, then you have the ability under what's called Section 84 of the Law of Property Act, 1925, to change the use if you can say that's a reasonable use. So I would expect some tenants of long leases to be in negotiation with their freeholders about changing use and getting the freeholder on board where office use or retail use is no longer profitable. Insurance, if ever there was an example of how leases are not the most practical of documents, this is probably it, because tenants have been saying, why is not the loss of rent provision under my building insurance that I pay for, pay the landlord for, covering me for the rent while I can't occupy the property? And why does my business interruption cover not cover me for loss of profits if I'm a retailer? And the answer to that is twofold. One is building insurance is very directed at physical damage to the property. Rent cessor provisions and leases are based on physical damage and an inability to occupy due to that. They don't cater for pandemics. And business interruption cover, which was looking at providing cover for notifiable diseases, etc. The insurers are all turning around saying, oh no, it doesn't cover pandemics. The provisions for insurance to be triggered by an outbreak of a notifiable disease within 25 miles of the premises is specific to that. You've got to show a loss caused by someone getting COVID within 25 miles. You can't claim for a loss caused by a national pandemic, which has had everyone in the country affected, and the government giving directions as to whether you can or cannot occupy your premises. There is a test case going through the court as we speak, brought by the Financial Conduct Authority against 8 sample insurers to establish whether business interruption cover does apply, does provide cover for pandemics. If that succeeds, then one expects a second tranche of cases about building insurance and loss of rent. At the moment, tenants are just simply not covered. And tenants' arguments about not being liable for rent based on frustration and other arguments just haven't succeeded. They are lawfully obliged to pay the rent. Which brings me on to rent collection. The government stepped in to try and protect tenants. They stopped forfeiture. They stopped almost all forms of debt collection. You can't levy distress, and you can't pursue statutory demands. That's all going to come to an end at the moment on 30th September. So one expects all hell to let loose then if it's not extended. But landlords are coming round to being collaborative. There is understanding the need to be. Various landlords have been incredibly generous in giving rent frees, and some agreeing turnover rents and new packages. The government saw fit to promote a voluntary code to try and get landlords and tenants to communicate, to get tenants to disclose financial information so the landlord could take a view on it. Not many tenants are happy to do that. But landlords are faced, certainly in the retail area, with a diminishing tenant pool. The number of CVAs and administrations is phenomenal. Landlords suffer very badly through those. So they want tenants to remain vital and trading. And sensible landlords are doing sensible deals with tenants to give them concessions, to give them time to pay, sometimes in return for the tenants agreeing to longer leases and further commitment to the premises. Okay, I think I've covered everything I need to, so I'll hand back to you, Ben.
Great, perfect timing, Jonathan. Yeah, I did want to make sure we got 10 minutes at least for the Q&A. Thank you all, it was really, really fascinating and links very closely to an event we had earlier in the week, Agents Insights, looking at the construction sector, commercial offices, and retail and residential space, and a lot of the themes kind of chime there. So if anyone in the audience does have a question for any of our panelists on either to Joe for furlough redundancies, reopening of offices, or Emily on the impact of COVID on the construction, or around property disputes and property litigation, please do pop a question in the Q&A box. We do have a question here already, and that is going to Joe. What are the rights of employees if they have concerns in coming back to the office? Do employers need to prove the office is COVID-19 secure? What if employees have concerns not directly related to the office, but for example, commuting to the workplace? So that's kind of a 3-parter there for you, Joe.
3 parts, that's very complicated. The truth is, it's always going to be fact dependent. So, I mean, one view is if, let's say I'm the employer, I've carried out my checks, I am comfortable that I've done what I need to do to make my workplace secure, and I ask Emily to come into the workplace. If Emily turns around and says, no, I just don't fancy coming in because I'm just concerned that I may contract the virus on the way into the office, then one view I could take is, well, there's no reason you shouldn't be attending work. I'm asking you to attend work. So if you don't come in, you're either not going to get paid or potentially I'm going to discipline you for being AWOL. That is the hardline approach that employers have been reluctant to take so far because it's all been very uncertain. But I think it's starting to harden up now, given we know things are going to continue for some time and we don't want to set precedents which could be abused. But the flip to that is it would all depend on the reason why somebody doesn't want to come into the office. So for example, if they happen to be living with an elderly parent who has an underlying health condition, that would be very different to someone who lives on their own, for example. Or if the employee perhaps isn't shielding because they haven't got any physical illness, but they, for example, suffer from extreme anxiety, and going into the office could make that worse. Again, you can see an argument there that actually it'd be quite unfair for the employer to insist that person come into the office. And if they did insist in those circumstances, potentially that could give rise to a claim that employee could resign and say that they've been treated so badly they had no option but to resign, or potentially bring a claim for discrimination. So using the anxiety example, anxiety is a disability in certain circumstances. So there's certainly claims that could be brought by employees if they don't want to come back into the office, but ultimately be understanding really the reasons behind it, and then the employer taking an informed view as to whether or not they should take a hardline approach, or actually be accommodating and agree, for example, for that person to continue working from home if there's sort of health issues at stake. So there's no need for an employer to prove they've got a COVID secure office. I mean, often it would be advisable for employers to at least explain to employees what they've done to give them peace of mind and to get employees sort of on board. But ultimately, the employee is not in a position to say whether or not they are complying. You know, only a health and safety advisor could really make a determination. So unfortunately, it's down to the employer to do what they think is the right thing to do in the circumstances, get themselves comfortable that they've done all they can, and then just explain to the employee, well, we've done what we need to, we think it's secure, we've done X, Y, and Z, so please come back. But there's no need to evidence it. And finally, in relation to commuting, the strict legal answer is no, you've got no sort of duties as an employer in relation to employees commuting. You know, an employee takes a job in Mayfair, they need to get to Mayfair. That said, we've never lived in a world where we've had a pandemic, and the sort of legal community think if someone wasn't alive and mindful to the fact that there are concerns on public transport, it could well and truly lead to employees resigning and looking to bring a claim. And I think a judge would be quite sympathetic to an employee if they had valid concerns. But again, it's all fact dependent. You know, someone who's suffering from a health condition will be in a far different position in terms of transport and not wanting to use transport than someone who isn't. So unfortunately, it's a bit of a case-by-case assessment on each of those questions. And if I'm honest, the answers aren't really there yet, but only time will tell.
Thank you, Joe. The next question from the audience, I'm not sure who's best to tackle this, but I'll ask it and see who wants to tackle it. With working from home probably here to stay on the long term, what are the implications on home insurance? Recent news have highlighted that a high proportion of home insurance might not be adequate for working from home. Could you explain what are the implications? Who wants to tackle that? No one?
I must confess, from my perspective, I don't know the answer to that. I think I'm right in saying that when the pandemic first kicked in, insurance companies agreed that people working from home as a result of the pandemic was fine, and there's sort of a temporary kind of permission, if you like, for that to continue. However, I think that only lasts until the end of the year. So I think at some point there will have to be some regularization of the situation, and it may well be the case that employees need to enhance their insurance. If that comes at a cost, who's going to be responsible? Presumably be the employer. But I don't know the exact answer. I don't know whether Jonathan or Emily have anything further to say, but I think at the moment it's fine, but I think things will change.
Well, I would just say a slightly different point that people who live in flats or rented accommodation probably have covenants to use it as their private residence only, and not to use it for business purposes. Ancillary business use is normally fine, but if you start making it into a proper office, I see Eddie Hearn is using his house for a boxing match and everything, and all the neighbours are up in arms about that. Then there are issues. But the fact is that I don't think anyone will get any sympathy from the courts in trying to stop anyone working from home. I'm not sure what the insurance risks are from working from home, other than from your spouse when you continually annoy them. But
I think that's a different area, and maybe that your team covers somewhere else. We've got a few minutes left. I want to come to each of you, and just, I know Emily touched on this a little bit, but I'll come to each of you and just to ask, what is the kind of the most common question that you are each getting in your own fields at the moment? Emily? You're on mute, sorry, Emily.
Sorry. For me, it's very definitely, I've got a project that's ongoing. The contractor tells me that they can't carry on works as effectively, and it's going to cost me more money and it's going to take more time. Is that correct? And it's really a case by case, fact specific analysis of each individual contract and exactly what the contractors tried to do to mitigate those risks. And sometimes it's a discussion between employer and the contractor, and you'll agree. And there are a few cases that we've got on now which the question arose in March and we're still arguing about it. So I think that's it really at the moment.
Great, thank you, Emily. Jonathan?
I think most common question is, I have a lease or a contract, how do I get out of it? How do I not have to perform it? Interestingly, for those involved in off-plan developments, flats and such like, which have long stop dates, there was a case yesterday about the importance for a developer of making sure all their certificates are in place by the long stop date to force purchasers to complete. You've got to realise that any purchaser is looking to get out or renegotiate. And it's vital that the contractual terms are met to the letter. Slackness, which would be of no concern before because everyone wanted to complete, is now the death knell for the vendors because everyone will use it to get out of the contract. So lawyers are busy looking for ways out, I'm afraid. You've got to make sure your ship's in order.
Thank you, Jonathan. And Joe?
And for me, I'm afraid it's redundancies at the moment. That's the big question I'm being asked. How do we make them fair? How do we go about doing it? And often, most employers do not want to make people redundant in these circumstances. And so there's the human element as well as the legal element. And how do we sort of deliver this news in a way which is humane, especially in circumstances where you can't meet people face to face at the moment. So yeah, for me, it's certainly the redundancy stuff.
Thank you, Joe. And just before I sum up to the audience, we've got a very short Zoom poll that would be great if you could fill out to give us any feedback for today. Obviously, it was a huge amount to try and get done in an hour. So if you do have any questions for anyone on the panel, or you'd like to get in touch with Forsters, do just let us know. You can contact us through our website at nla.london. And we obviously have got a lot of events and activities coming up over the coming months. Thank you to our audience for coming along on what I think will be the hottest day of the year. I'm certainly boiling here, don't know about you guys. And thank you to all of our speakers for those really fascinating presentations. We're looking forward to see what happens over the next 6 months. Enjoy the rest of your day and have a great weekend, everyone. Thank you.
Thank
Bye-bye.
you.